You know that feeling when you shake hands on a deal, you look the other person right in the eye and say, hey, we'll figure out the exact details later. I mean, it feels completely natural in the moment, right? You trust each other, you want to get the ball rolling, and you just kind of figure the paperwork is merely a formality. But here is the million-dollar question. Can you actually sign a contract to make a contract later? Does the law actually protect that initial handshake? Well, today, we're going to find out just how incredibly dangerous that assumption can be.
Welcome to The Explainer. Today, we're unpacking a really fascinating and honestly heavily litigated area of contract law called certainty. We're going to completely demystify what it actually takes for an agreement to be legally binding and why courts are so incredibly strict about the details. We'll be looking at real historical cases where millions of pounds were on the line and where massive steel structures were literally left hanging in the balance, all because of just a few missing words.
So here is our agenda for today. 1. The rule of certainty. 2. The danger of incompleteness. 3. Agreeing to agree. 4. Lock-in and lock-out agreements. And 5. The restitutionary approach. Let's dive right in.
Starting with Section 1, the rule of certainty, or as it's often known, no guessing allowed. Listen, for a contract to be enforced by a judge, its terms absolutely must be certain. The courts are in the business of enforcing agreements, not writing them for you. If you leave key terms out, the court will flat out refuse to step in and just guess what you probably meant. And the reason for this is actually pretty simple. Markets are volatile. Circumstances change. What seems like a totally fair price today might literally bankrupt you tomorrow. And this brings us to a foundational legal concept, consensus ad item. In plain English, that translates to a meeting of the minds. It's the essential foundation of a contract where both parties completely agree on the precise terms. If there is no meeting of the minds, say you think you're paying one price and the other person thinks you're paying another, or you just assume the other side knows what you mean, then your agreement is really just vague conjecture. Without this absolute consensus, you simply do not have a contract. Period.
Which brings us to Section 2, the danger of incompleteness and what happens when vital details are left out.
And that leads us straight into Section 3, agreeing to agree, featuring the classic case of May and Butcher versus R. To really understand the real-world chaos that happens when parties leave out critical details, we have to look at how dangerous incompleteness can be. And honestly, it happens all the time in business. Two companies want to lock down a partnership fast, so they sign a document outlining the broad strokes, but they leave specific pricing or delivery dates completely blank. They think they've built a safety net, but legally, they might be standing on a trapdoor. Let me paint a picture for you with this famous piece of case law, May and Butcher versus R. The year is post-World War I. The British government finds itself sitting on this incredibly massive, almost burdensome surplus of army tents that they just don't need anymore. They are absolutely desperate to liquidate this inventory. So the government's disposal board agrees to sell these tents to a company called May and Butcher Ltd. Now, at first glance, it looks like a totally solid deal. May and Butcher even leave a very substantial £1,000 security deposit to secure their purchase. But here is the fatal mistake. The written agreement stated that the price of the tents and the dates for payment were to be agreed upon from time to time. They literally agreed to figure it out later. They basically signed a piece of paper saying, hey, we promised to sign another piece of paper later. Well, as you might guess, a dispute arose and the whole thing ended up in court. The court took one look at this contract, saw the missing price and delivery dates, and declared it utterly void. They established a massive precedent. An agreement between two parties to enter into an agreement where critical terms are left unsettled, an agreement to agree, is simply too uncertain to be a valid contract. Think about it. You can't legally bind someone to negotiate with you in the future just to figure out a price. How on earth can a judge enforce that? What if you legitimately can't agree because the market for surplus tents is completely shifted? The court cannot and will not force a price upon you. And here is the truly wild part. That £1,000 deposit, which in the business world feels like the ultimate binding commitment, it meant absolutely nothing without those core terms defined. The contract was dead in the water.
Moving on to Section 4. Lock-in and lock-out, exploring modern negotiation tactics.
So businesses today are highly aware of the May and Butcher rule. They know better than to just vaguely agree to agree. Instead, they use these highly sophisticated pre-contractual tools called lock-in and lock-out agreements to try and secure a deal while they hammer out the finer points. But watch out, because these tactics carry their own massive legal risks under the rules of certainty, which was heavily litigated in the landmark case of Walford versus Miles. The difference between these two concepts is a huge trap for negotiators. Let's break it down.
A lockout agreement is essentially a negative promise. You are promising not to negotiate with anyone else for a set period. The courts in Walford versus Miles confirmed this actually can be a valid contract, but only if it has a strict, certain time limit. So if you say you can't talk to anyone else for exactly 2 weeks, that's certain. A lock-in agreement, however, is a positive promise. It tries to force exclusive negotiation with a specific party, and the courts generally hold this as way too uncertain. Why? Because at the end of the day, it's really just an agreement to negotiate. You absolutely cannot force two parties to sit in a room and successfully negotiate a contract if they simply don't want to. It lacks the certainty required for legal enforcement, making it, you guessed it, just another invalid agreement to agree.
Finally, let's look at Section 5, the restitutionary approach, featuring the case of British Steel Corp versus Cleveland Bridge.
Okay, so we've talked a lot about contracts failing because they're too uncertain. But what actually happens in the real world when a contract fails for uncertainty but the work is already started? Have you ever found yourself in a situation like this, where you've delivered on a promise, shipped a product, or put in hours of hard work without finalizing the paperwork, just assuming the contract would get signed eventually? And then suddenly, negotiations break down and poof, there is no contract. What happens next? Are you just completely out of luck and out of money because of this strict rule of certainty?
Well, let's look at the facts of the British Steel Corp case to answer exactly that. So Cleveland Bridge was building this massive project, and they desperately needed these gigantic steel construction notes. They sent a letter of intent to British Steel Corp, basically saying, hey, start making these, we'll sort out the formal contract later. Now pause and think about how wild this is for a second. British Steel actually went ahead and manufactured these incredibly expensive custom steel nodes. We are not talking about paper clips here. These are colossal, incredibly heavy pieces of infrastructure that are an absolute nightmare to transport. And they delivered them. But as you can probably guess from our theme today, the formal contract negotiations totally failed. There was zero finalized contract. Yet the defendant, Cleveland Bridge, retained the benefit of those massive steel nodes. They kept them and actually used them for their project.
So here is the tricky part. Because there was no formal contract due to incomplete negotiations, British Steel couldn't sue for breach of contract. I mean, you can't breach a contract that legally doesn't exist, right? But instead, the court stepped in with a brilliant alternative solution: the law of restitution. This area of law fundamentally exists to prevent unjust enrichment. The judge ruled that sure, there was no certain contract, but it would be wildly unjust for Cleveland Bridge to just keep massive custom-built steel nodes for absolutely free. The court ordered them to pay the reasonable value of the goods provided. And this is a massive takeaway for anyone doing business. Where a contract fails for uncertainty, but one party has already benefited from the other's work, the law of restitution acts as your safety net to ensure fairness. Now, you won't get full contract damages or your expected profit margin, but you will get paid the reasonable value of what you actually provided.
Wow. Okay, so we've journeyed all the way from the strict requirements of a meeting of the minds, through the catastrophic failures of leaving details to be decided later, and finally to the legal safety net of restitution. I want to leave you with this one thought to really reflect on. The next time you shake hands on a deal, whether it's a massive corporate merger or just hiring someone to paint your house, ask yourself, do we actually agree on the specifics, or do we just agree to agree? Honestly, getting that answer right up front could save you years of legal headaches. Thank you so much for joining me on The Explainer, and keep learning.